All right, at this time, I'd like to call the Castle County Planning Board special meeting to order for Tuesday, November 15th, 2022, 1 p.m. The purpose of the special meeting today is the Watershed Review Board Appeals hearing. And that is the second item on the agenda. And at this time, I'll entertain a motion to go into public hearing for the Watershed Review Board Appeals hearing. I make a motion that we go to. Okay. Motion by Mr. Foster to enter the public hearing. All those in favor, please let us know by saying aye. Aye. All those opposed, like sign. Motion carries. We're now in the public hearing for the Watershed Review Board Appeals hearing, and the chair will recognize our planning board attorney, Robert Hornick. And Mr. Hornick, if you could please just give us some background information as to why we're here and then the procedural issues for this meeting.
Thanks, Mr. Johnston. Good to be here. Good to see everybody here today, and it's especially good for us to have a quorum of the board today, so that we can actually conduct some business. I guess the appellants probably know what this is all about. This is an appeal by various appellants from the issuance of watershed protection permits and the non-residential SNIA permit. I forget the name, to tell you the truth at the moment. But for the two Sunrock plants, permits were issued in early 2000. COVID hit. Things have taken a long time for us to get here, but here we are. I want to explain that specifically, we're not here to take testimony from anybody today. Sunrock's counsel has moved to dismiss the appeals. The county has joined in that motion, and Mr. Connor, Ms. Arata, and Ms. Bateman, on behalf of their respective clients, have opposed the motion to dismiss the appeal. What we're going to do today, at least the plan is that counsel will have an opportunity to present their arguments in open court, so to speak, in support of or in opposition to the motion. The way the process works is that Mr. Johnson is the chairman of the Watershed Review Board. And one of the things I want to clarify is that while this is the planning board, they sit here today wearing their hats as members of the Watershed Review Board pursuant to Article 10 of the UPO. So the chairman of the board will initially make a ruling on the motions. Depending on what the ruling is, or regardless of what the ruling is, one or another party may appeal that ruling to the whole body of the board, to all the board. It is not necessarily the case that Mr. Johnson is going to make a decision today. Depends on the clarity of the arguments and how the legal issues pan out, and whether he feels that he is in a position to comfortably make that decision today. So that's, I guess, the nuts and bolts of why we're here today. One of the first things I want to do before I'm speaking into the microphone. I mean, I don't know what to tell you. Sure.
Pull it closer to you.
Hopefully this is a little bit better.
Is that a green light?
It's green. I'll repeat everything I just said. No, I won't. So rather than, I'll just shout as loud as I need to shout so everyone can hear. Can you hear me now? Yes. Well, I'm doing the best I can. In any event, the first bit of business that I want to take care of is asking the board members, if any board member feels as if they have a conflict that would prevent them from participating as a board member in the hearing of this matter.
This is Scott Oakley. I would ask the board to recuse me since I have some history prior to this coming into play.
I recall that at the outset, the very beginning of the appellate process, that maybe even before there was an appeal, Mr. Oakley had been involved in speaking in opposition to one or more of the applications. So I think that probably could create the appearance of a bias or a conflict. And in that case, I would suggest to the board that you accept Mr. Oakley's request to be excused from participating in the hearing and vote to allow him to be excused.
Okay, so we need to have a procedural vote?
Yes.
Okay.
I'm sorry, could you just repeat those remarks that he made, because I couldn't hear them, and I'm sitting right here. I just didn't hear your remarks, sir, and I didn't understand your response because I didn't hear his remarks.
Mr. Oakley has asked to be excused from participating in this hearing because early on in the process, I know he was reported in the media, among other things, as being opposed to the Sunrock proposed developments that are the subject of the hearing. And that, in my view, creates at least the appearance of a bias. And I don't want to give anybody an automatic grounds for appeal. That's why I asked the board to excuse Mr. Oakley from participating in the matter.
Okay, at this time, fellow board members, I will entertain a motion to allow Mr. Scott Oakley to recuse himself from this special meeting.
I'll make a motion for Scotty to leave.
That motion is made by Steve Thompson. All those in favor, please let me know by saying aye. Aye. All those opposed, like sign. Motion carries. Mr. Hornick, any other procedural issues or other comments before we proceed?
Nothing particular, though I do know that you have a few comments to make before we start.
I didn't hear that.
Could you turn the speaker on?
Some boy stand up and you will see. Yeah, some didn't work. But turn it up. I mean.
Trying to figure out how to.
Mr. Hornick, could I be heard before you move on?
I don't know if it can be heard.
Well, you know what I mean.
Yeah.
I just, since Mr. Oakley has been very honest, to come forward and say that he's had said some things in opposition to some of the Sunrock projects, I just would want, I would respectfully request that the rest of the board members consider whether they have said anything in favor of the Sunrock. If they have, I'd ask for the same recusal of those members.
Are there any board members who have come here today with a fixed opinion about whether or not, don't tell me, I've got this covered. Okay, Jim?
That's not what he said. He didn't say he had a fixed opinion. He said months ago, he said something. That's what he said.
Does anybody feel as if they cannot honestly and fairly and even-handedly hear this case and make a decision without a bias for or against the application? Each board member feels as if then, other than Mr. Oakley, feels as if they can be honest, fair brokers in connection with this application if it comes a point in time when you have to make a decision. I see all board members are nodding their head.
Well, then I'd ask that Mr. Oakley's motion be reconsidered on the same grounds. Does Mr. Oakley feel that he cannot fairly consider this today and has a fixed opinion that cannot be changed by the arguments? That's the question you ask everybody else. That ought to be the same question for Mr. Oakley.
Mr. Oakley has already been excused, and I think we're done with this issue at the moment.
Okay, can everyone hear me now? Can everyone hear me? Okay, great.
These aren't working. You would speak more slowly.
Sir.
These aren't how.
Mr. Chairman,
Yes, Mr. Oakley.
if it's in keeping with procedures, if we can recess for a few minutes, I'll go get Carla, the clerk of the board downstairs. She may be able to help with the microphones.
Certainly, that's not a problem. We'll take a brief recess.
That's all.
Testing, testing. Can you all hear that? Testing, testing. Can you all hear that in the back? I'm sorry.
That's. Testing, testing. Can you hear? One, two, three. Testing. Mr. Morgan. Yes, test the microphone. Test, test. 1, 2. Test.
Test. Test. Yeah.
All right, at this time, I will call the special meeting back to order. Mr. Horn, the chair will recognize Mr. Hornick again to address the appellants that have withdrawn their appeals. I just want to acknowledge on the record that over the course of the last week, we received emails from Herman Roberts and Jean Roberts, Sylvia Saunders, Jennifer Connor, John Connor, Homer Saunders, Kim Merritt, and Junior Merritt, indicating that they wish to withdraw their appeals so that we have deemed those appeals on behalf of those eight appellants to be withdrawn. Thank you, Mr. Hornick. I just have a brief statement that I will read to the appellants and the appellees. In late September of this year, Sunrock filed a motion to dismiss the appeals. Council for all parties have had a chance to review that motion and to respond to it, and to make any motions they may feel appropriate. Castle County has joined in Sunrock's motion to dismiss. This statement, on behalf of our clients, Anita Faust, Byron Schaffner, and the Day Holt chapter of the NAACP, and Mr. Connor, and Ms. Arata, on behalf of their clients, have submitted written opposition to Sunrock's and the county's motion to dismiss. Today, the Watershed Review Board is here for the limited purpose of hearing the motions to dismiss. Per statute, the chair of the Watershed Review Board has the authority to hear and decide motions such as Sunrock's. If any party to the appeal is aggrieved by whatever decision the chair makes, they may appeal the chair's decision to the full Watershed Review Board. All council have conferred about how we will proceed today. We have agreed on the following process. Counsel for the parties will each have 15 minutes to present their oral arguments regarding the motion to dismiss. Since this is Sunrock's motion, counsel will go first, followed by Castle County's counsel, then by Ms. Haven, and finally Mr. Carner. Once the oral arguments are completed, the chair will either make a decision on the motions or take the arguments under consideration, and the decision will be issued at a later date. I advise everyone present that the issues presented by this appeal are complicated, and it is my responsibility to fully and fairly consider all arguments. Once a decision has been made by the chair, whether now or at a future meeting, again, if any party is aggrieved by the decision, they may appeal to the entire Watershed Review Board. The board members are present here today, so they will be in a position to consider an appeal if one is filed. In the event that the decision on the motions being heard today does not fully resolve all issues, then the board will set a future date for hearing whatever issues may remain. So with that being said, Mr. Hornick, are there any other procedural issues before we begin?
I think that covers the procedural issues. Of course, so that everyone's aware, the board members or the chair may ask questions of council as they raise their arguments. So just we can anticipate that. I want to make sure that the board knows, even though you're not participating in the initial decision on the motion, if you have questions that will need clarification on any point that council makes, feel free to ask a question. Because what we want to do is we want to get as much information as we can so that we can make the right decision. So don't be shy about asking questions.
Thank you, Mr. Hornick. With that being said, are all board members ready to proceed? Okay, so the chair will now recognize Sunrise Council. If you may address the board, please.
Thank you very much, Mr. Chair. My name is Bill Bryan. Here with my partner, Jeff Rother, who represent Sunrock. I was given to understand that we will be addressing me from a seated position, which is a little unusual, but that's necessary for the camera. So I am just no disrespect for failing to stand. As I mentioned, I'm here on behalf of Sunrock, Carolina Sunrock LLC, to address our motion to dismiss, which was filed.
The system's not working. We can't hear.
See, the button on green.
Well, it's on pretty loud. You want me to talk closer? Is that helpful? All right. Okay. Our motion to dismiss was filed on September 19th, 2022. I have additional copies of that motion if anybody would like to see one. And I'd like to ask that the motion be included as part of the records. And I'd also like the board to take particular notice regarding the contents of the county's UDO, specifically UDO section 10. The issue before the board today relates to the board's jurisdiction. It is a pure matter of law. There are, well, when I was preparing for this, there were 52 appellates before the board, appeals that were pending before the board relating to the watershed permits that were issued to Sunrock. I don't know how many appellates are left, but however many there are, there's a lot, at least 48 or 49. Sunrock believes that these appeals are wrong as a matter of substance, but even before we get to the substance, we need to determine whether we're even in the right place to hear the arguments on the substance. The board's job today, therefore, is not to decide whether the appellants are right or wrong. The board's job is to decide this is the right place to decide whether the appellants are right or wrong. And I'd like to reserve a couple of minutes at the end to respond to some of what my colleagues may say on the other side. So jurisdiction is the power that the board has, or any court has, in your case. In other words, boards like this have certain specific jobs to do, and anything beyond the board's job description is beyond its jurisdiction. But what is the job of this board, therefore? State statutes allow the county to create a specialized board to hear technical appeals, and that's what the county has done here in designating the planning board to be its watershed review board. It is a specialized board whose job is to hear technical appeals, specifically the Caswell County UDO, and I've got a copy of the two sections. Says that the UDO says the job of the watershed review board is to hear and decide appeals from any decision or determination made by the watershed administrator in the enforcement of the county watershed protection ordinance. It's not to make broad issues, it's not to hear broad arguments about other issues of law. It's limited to the watershed protection ordinance. So in this case, Mr.
Excuse me, Bill, I'm sorry to interrupt, but you handed something to the board, but you didn't provide a copy to opposing counsel. Can you do that?
There should be plenty of copies for everybody. Sorry about that, Jim. It was intended.
I think he would slow down your speed, sir. He put up his hand.
Well, I may have to have more than 15 minutes if that's the case. Mr. Hoagland, wearing his hat as the watershed review administrator, considered Sunrock's application for watershed permits on the technical requirements of the ordinance, and he issued the permits because he determined that the permits met the requirements of the ordinance. And to the extent that somebody challenges that whether the permits meet the requirements of the ordinance, that appeal is properly before you. The extent that somebody challenges some other ordinance, brings up an ordinance like the high impact development ordinance or the moratorium ordinance or anything else, no decision was ever made on any of those points by Mr. Hoagland, and those issues are not properly before you. So the board's job is limited to interpreting and applying only the county watershed protection regulations. So in this case, nearly every appeal is based on something other than Mr. Hoagland's application of the watershed protection regulations. As you can see from the papers that were filed by Mr. Connor, the appellants he represents made a single argument that the moratorium in Caswell County prevented those permits from being issued, and that the county's decision to recognize Sunrock's vested rights against the moratorium was a mistake. Mr. Connor does not in his papers mention that the moratorium expired over a year ago, and therefore it's irrelevant. Also, regardless of that, this is not the right board to hear appeals regarding the moratorium ordinance or the complicated legal issues relating to Sunrock's vested rights. This board's only job is to decide whether Mr. Hoagland correctly applied the technical requirements of the watershed protection ordinance, and Mr. Connor has nothing to say about that issue. In other words, Mr. Connor's clients are not appealing a decision or determination of the watershed administrator in the enforcement of the watershed regulations. So there is nothing for this board to hear on those appeals. Now, Ms. Bateman's clients have different arguments that they make. First, Ms. Bateman's clients argue that Mr. Hoagland's decision violated regulations adopted by the North Carolina Department of Environmental Quality. So she argues that this board should be applying state law to override the terms of the watershed protection ordinance. These arguments also are beyond the board's jurisdiction because they ask this board to disregard the county watershed regulations and apply state law in their place. It is not this board's job to ignore the county watershed regulations as written. If those regulations are incorrect, Ms. Bateman's clients should sue the county. in court to change the ordinance. The second argument Ms. Bateman's clients make is that the high impact development ordinance should have prevented Mr. Hoagland from issuing these permits. Again, this argument has nothing to do with the application of the county watershed regulations, and therefore is beyond this board's jurisdiction to decide it. Mr. Hoagland never made any decision about relating to the HIDO in his capacity as the watershed director, and any argument about the HIDO belongs in court. The only argument that Ms. Bateman's clients made, which belongs before this board, is that Mr. Hoagland misapplied the watershed regulations because the Jordan Lake watershed has been designated as a critical area. This argument is wrong, in our opinion, but it is an argument that the board should hear because it's based on county watershed regulations. And the Jordan Lake, the watershed regulations rather than some other legal principle. So of the 52 appeals that are pending before this board, only 3 are properly before the board. And of the arguments made in those 3 appeals, only one argument is that Mr. Hoagland, only one of the arguments is an argument that Mr. Hoagland failed to properly apply the watershed regulations, which is what this board job is to determine whether he did or did not properly apply the technical watershed regulations. The other 2 arguments are beyond the job description of this board.
Mr. Bryan, can I ask you a question?
Yeah.
Regarding the argument with respect to the moratorium ordinance. What, if you know, what was the moratorium on? Was it on the whole UDO, or was it somehow more specific?
I don't know off the top of my head.
The reason I ask the question is that watershed review regulations are part of the UDO. So if the moratorium was on the effectiveness of the UDO, broadly speaking, wouldn't moratorium likewise apply to the watershed review portion of the UDO?
I think the moratorium was on the issue of the building permits. Does it, on any approval required by Caswell County for including industry development? It shall be unlawful and a violation of the ordinance for any person within the jurisdiction to which this ordinance applies to engage, including industry development activities that require a Caswell County development permit or approval, or a state or federal water quality permit or approval. And in that 1-year moratorium, the board was supposed to be studying and revising its ordinances. And then it would, and 1 year moratorium, as I said, has expired. So from our perspective, it's no.
Thanks.
One of the things that Mr. Connor argues, and I think it's important to note, is that this board has all the powers of a board of adjustment. That is not the case. This board specifically does not have the authority to hear vested rights appeals under 160D 108H. That is a power which is granted only to the Board of Adjustment. And I might add, it is only granted to the Board of Adjustment in a limited situation where somebody who is asked for determination of vested rights has had that determination denied. So not just anybody can go to the Board of Adjustments to ask for vested rights determination, only a person. So Sunrock would have had to have asked for determination from the county and had that determination rejected in order for there to be an actual case of controversy to take to the Board of Adjustment. This board does not have the power to make determinations regarding vested rights under the statutes or under the common law. One of the other things, one of the last things I want to say is that there was some discussion in Mr. Connor's papers to the effect of that the lawsuit that we filed, and there's no question that we filed a lawsuit against the lawsuit that we filed in some way has already made this decision for you, already determined that this board has jurisdiction. That is not correct. Right after these appeals were filed, Sunrock filed a lawsuit in Superior Court asking for two things. One, for a declaration that this board does not have jurisdiction, the very argument that we're making now, over the issue of vested rights. And two, for a determination by the court of its vested rights. And what the court said in a motion that was filed by Ms. Bateman's clients, what the court said was that the court couldn't make that decision until you made a decision about whether you think you have jurisdiction. And they said it was premature. It was a premature lawsuit for us to have filed, and that we need to go back to you, have you make that decision, and once that decision is made, that could be appealed to the Superior Court. The court specifically did not say that this board has jurisdiction over the issue of vested rights. That's very different than what Mr. Connor said. And even though that decision really only applied to Mr. Bateman's clients, reasoning was the same for all the parties. And so rather than wait for I don't know how long until Mr. Connor decided to make a motion to dismiss on that ground, and he could have made that motion at any point in the proceedings, including on appeal, that's where this matter came up. We decided to dismiss the case, bring it back here, have you ask you to make that decision, respectfully ask you to make that decision, and then whoever prevails on that point will be able to go back to Superior Court. So in summary, we're asking for the complete dismissal of all the appeals filed by Mr. Connor's clients. We're also asking that the appeals filed by Ms. Bateman's clients on all issues except for the one relating to the alleged misapplication of watershed regulations be dismissed. If our motion is granted, as Mr. Hornick noted, we will reconvene on a different date to determine if Ms. Bateman's clients have standing to file these appeals in the first place. And if so, then to hold an evidentiary hearing on whether Mr. Hope would probably apply the watershed ordinance when he issued the permits. So granting this motion will dispose of over 50 appeals, and we're focused on whether Mr. Hope would properly apply the county watershed regulations, which is what it is supposed to be doing, which is the technical issue that this board has been created to address. If our motion is not granted, the next step will be that each of the appellants, all of them, individually, will have to appear before this board to testify about how they have been specifically and individually damaged by Mr. Hope's decision. In order to appeal these permits, the appellants have to show that they have standing. In order to show standing in this case, you have to show special damages. Special damages are damages individual and specific that are different from any damage that's suffered by everybody else. So this board, part of the showing that will have to be made will that each one of these appellants will have to come forward and show how they specifically and specially have been damaged differently than anybody else in Caswell County in order to maintain their case. That hearing will take a long time for 50 appellants or 48 or however many there are. Therefore, we request that you dismiss these appeals so this process can be completed. Thank you for your attention. I'll be glad to answer any questions that you may have.
Thank you, Mr. Ryan.
Is that a 15-minute one?
Yes, sir, right. Thank you. Fellow board members, any questions for Mr. Ryan, Carolina Sunrise Council? Seeing that there will be no questions, Mr. Hornick, is it appropriate to recognize Mr. Farrell, the attorney for Caswell County? Mr. Farrell, the chair now recognizes Brian Farrell, attorney for Caswell County.
Thank you, Mr. Chair. My name is Brian Farrell. I'm a lawyer with the Ken Craver firm in Durham. I'd like to start by thanking the board for your service. I know these hearings take a significant commitment and time and effort on your behalf, and the county appreciates your work. At the outset, it's important for me to state the county's interest in this matter and resolving these appeals as efficiently as possible. I understand there have been a number of delays in bringing these cases forward for various reasons. However, none of these delays are the result of county staff initiated delays. The county has no interest in artificially or arbitrarily limiting a resident's ability to appeal or present their case. However, the appeals before you are subject to the same laws and procedures applicable to any quasi-judicial land use matters. And it's important for the due process rights of all the parties that those laws and procedures be followed. Now, my role in this hearing is to represent the county and its staff, in this case, the watershed administrator, with regard to the permits issued under the watershed protection regulations. This is, as you know, and as you've already heard, a technical decision for the chair and perhaps the board today. My arguments reflect no judgment on the merits of the project writ large. Rather, it turns on the technical question of whether we're in the right place for the subject of these appeals. Now, the various parties have different positions on the motions to dismiss before you, and they're represented by capable counsel as you are. And I know you'll rely on counsel and the arguments in rendering a fair decision today. Now, as you've heard and as you know, the watershed administrator and this board serve important but limited roles in the county's development review process. The responsibilities of the watershed administrator are limited as outlined in the actual definition in the ordinance about those responsibilities, which says that the watershed review administrator's responsibilities are administration and enforcement of Article 10, Part 2. That's as far as the watershed administrator can go in reviewing development projects. As a quasi-judicial appellate board, the powers and duties of this body are set forth in section 10.10.6 of the Unified Development Ordinance. And that says your role is to hear and decide appeals from any decision or determination made by the watershed administrator in enforcement of the watershed protection regulations found in Article 10, Part 2. That language establishes the jurisdictional boundaries of your work and the work of the watershed administrator. It's the county's position that the Watershed Review Board has the full authority and jurisdiction to determine if the decisions of the watershed administrator to issue the watershed protection permits and the SNIA permits that are the subject of this application were in violation or are in violation of the requirements of the county's watershed protection regulations in Article 10, Part 2 of the UDO. However, it's also the county's position that the watershed administrator in the first instance and the watershed review board in reviewing those decisions don't have jurisdiction and authority to make decisions over whether development projects in the county have vested rights generally, whether or not the county has applied other ordinances it has on its books, such as the high impact development ordinance, which isn't part of the watershed regulations, or to impose other state laws not included with the watershed regulations. I believe those counties' argument is that those items are outside of the reviewing jurisdiction of this body. Now, it's my understanding that the group of counter appellants, I'm going to refer to the counter appellants and the abatement appellants just because they're two groups with two separate arguments. My understanding is that they're asking the board to overturn the permits at issue because the applicant didn't have vested rights to proceed with them while the moratorium was in place, and that the high impact development ordinance should have applied to the projects at issue and they weren't made subject. My further understanding that the Connor appellants are not arguing that the watershed administrator otherwise, and misapplied or erroneously issued the permits based on the specific requirements contained in Article 10, Part 2 of the UDO. If that's the case, based on the jurisdictional limits that you've heard about and that are contained within the ordinance, the county argues that the appeals by Connor appellants should be dismissed because you don't have the jurisdiction to hear those issues. Now, it's clear the parties disagree over whether or not the appellant has common law vested rights to proceed with its project and whether or not the IDO applies to it. That's obvious from the responses and the filings that you've seen. Those issues just simply aren't properly before you. They've been the subject of litigation, as you've heard, and they may be resolved elsewhere, but not here. To the extent that the Connor appellants have any other issues, and I believe they have the ability to bring them forward now, related to the strict application of the watershed review regulations, again, I do believe those could be properly before them. Now, as to the abatement appellants, to the extent their appeals rely on vested rights, determinations, or application of the HIDO, I believe those appeals should be similarly dismissed. I agree with what the abatement appellants wrote in their response to the motion to dismiss, that the watershed protection regulations do not repeal, modify, or amend any other state or federal rule or regulation. That's clear from the text of the UDO. The pending projects must comply with all applicable state and federal law, and residents have the ability to take full advantage of any rights or remedies thereunder. However, the watershed review administrator is not free to search for federal or state law for items that may impact the proposed development and apply them to watershed permit application. As we discussed, the administrator's role is limited to applying the provisions of Article 10, Part 2. Now, to the extent the abatement appellants cite the specific errors in application or interpretation of Article 10, Part 2 that were made in the permits at issue, it's the county's position that those issues should be identified by the board, and we should have an evidentiary hearing on it. To the extent the abatement's appellants believe the watershed administrator should have considered, applied, made determinations about state laws or regulations not directly related to Article 10 permits, then those issues should be dismissed. Again, the county appreciates your time and attention to this matter.
Mr. Farrell, can I want to ask you a similar question to the one that I asked Mr. Bryan. What, if any, impact did the moratorium ordinance have on the Article 10, Part 2 of the UDO, the watershed review regulations?
Right. It's my view that the moratorium in this case didn't have application.
Explain
Right.
that more.
I think if the moratorium had applied, the permits wouldn't have issued.
Thank you, Mr. Farrell. Fellow board members, any questions for Mr. Farrell?
Johnson. Could Mr. Farrell repeat his last statement about the moratorium applying?
If the moratorium was applicable, the permits would have issued.
Would have issued?
Would not have.
Mr. Hornick, is it now proper to recognize Mr. Connor? Okay, again, fellow board members, any questions for Mr. Farrell? Okay. Chair will now recognize Mr. Connor. Oh, excuse me, Ms. Baker, my apologies.
No worries. Thank you. Can everybody hear me? Great. I like an audience. Okay. I am so happy to report that Mr. Brian and I have found something we can actually agree on. And what we can agree on is that the board's job is to decide whether Mr. Hoagland and the county made a mistake in issuing these permits under the county ordinances. Now, I will tell you that's not the end of the inquiry, and I'm sure this is where Mr. Barrow and Mr. Bryan and I will disagree. Because I don't think the county can issue permits if they know the issuance of those permits conflicts with state and federal law. And I'll tell you why. I am no fan of the federal government. And I never represented the federal government. I never plan to represent the federal government. I'm not that big a fan of state government. If I'm a fan of any government at all, I'll tell you what government it is. It's local government. And that means people like you, because that's where the rubber meets the road for the citizens. It's people like you who are responsible for making decisions that impact the citizens' everyday lives. And local government, for example, is responsible for keeping our neighborhoods and streets safe, right? And that's a huge impact on ordinary citizens. Local government makes sure that our children are educated. That has a huge impact on citizens. I want to echo Mr. Barrow's thanking you for your service because it's critical to the functioning of local government that people like you stand up and participate. I will tell you, despite that background, however, that at some point the federal government decided that it was going to tell us all how the environment should be regulated. And so it passed some laws and set some minimum standards. For example, it passed the Clean Water Act, and it passed the Safe Drinking Water Act. And because it needed somebody to do this, because they love acronyms, it created the EPA, the Environmental Protection Agency. Okay? And they said, EPA, you go out and you adopt some rules and you enforce these laws, right? So the EPA did that, started doing that. And then the EPA went, oh my God, we're gonna need a lot of people, we're gonna need a lot of money to do all this. And then Congress said, whoa, okay, well, maybe we'll do what Congress loves to do, which is then say, why don't we get the state to do some of this for us, right? Instead of the federal government doing it all, we'll just tell the state they can do it. And that they have to follow our rules. They have to implement these minimum standards. They can't do anything that goes below our minimum standards, right? So they did that. And of course, this state, in particular North Carolina, said, whoa, yeah, we want to get into this business. So yeah, we'll take this on. So they have some statutes, right? And they had to create their own little EPA, the North Carolina Department of Environmental Quality, right? And that agency, DE2, has some different divisions. One is the Division of Water Resources. One is the Division of Energy, Minerals, and Land Resources. And they said, we're going to pass some laws, and we're going to adopt some rules, and we're going to get into this business. And then the state had the same realization that the federal government did. That it, when it passed some of this off to local governments. But when it did that, it said, hey, just like the feds told us, we're telling you, you can't have any standards less than the standards we have, which are not less than the standards the federal government has. So you see how it gets down to you. This watershed protection regulation thing that you all adopted, that Castle County has, that governs what you do, the state created a model ordinance for counties to adopt. And you know what? The state can't set standards less than the federal ones. So the federal government gives to the state this authority, and the state gives to you this authority. But at no point does this authority ever change. It's the same minimum standards that the federal government created when it took over the environmental protection. Okay, so don't tell me you can act in conflict with federal state law. You can't. I mean, that's just where all of this comes from. There's the federal law, we gave it to the state, we gave it to you, but everybody's bound by these federal minimum standards. Now, if you look at your own regulations, and I don't necessarily, this is where I could end and say that's the relationship of federal law to what you're doing. And I could say, we're arguing that Mr. Hoagland did not properly apply the county's ordinance. That's our argument to you. I don't care what other people tell you our argument is, that's our argument to you. The county made mistakes when they issued these two permits. I can get into the merits of that, but everybody's been telling me that's going to wait for another day. I'm just going to give you a preview, though, of our argument. There are two permits that Mr. Hoagland issued. One is the SNIA, the Special Non-Residential Intensity Allocation Permit. The other is the Watershed Protection Permit. Your authority, his authority to issue these permits comes right from the watershed regulations. All right? There are two places where special non-residential intensity allocations are referred to. One is in 10.8.3.3.2, and the other is in 10.8.5.3.1. Those two sections are the only places that SNIA permits can be issued. And I want to tell you, in both of those sections, there is a separate section that talks about that watershed and what uses are prohibited, okay? And in both of those sections, it says storage of toxic and hazardous materials is prohibited. It's prohibited unless a spill containment plan approved by the county is implemented, okay? So I just want to go to this. I don't know if you have it in front of you, but if you go to the SNIA permit, there's a list of hazardous materials. Okay, diesel fuel, number 4, used oil, liquid, asphalt. Then there's a list, provision below that says, please provide the following: blueprints depicting the built-upon area. Number 2, evidence that the development has, to the extent practical, been so designed as to minimize storm water runoff offsite. If you look at the transmittal letter where they sent this to the county, they sent a $100 check in and the permit application. There's no list of any spill containment plan. And yet your own regulation says that storage of toxic and hazardous materials is prohibited unless the spill containment plan approved by the county is implemented. I don't see any evidence of a spill containment plan in this record. I've never seen any spill containment plan, but let's just say they did one. Let's say they did do a spill containment plan. Let's then look at the evidence that the development has, to the extent practical, and is so designed as to minimize stormwater runoff off-site. In fact, if you look at the plan, This site, this development was designed specifically to pipe the stormwater and process treatment wastewater off-site. Off-site, it goes right into the creek. It was designed to go off-site. It was never designed to go onto the property, to spray on their own property. I mean, the whole point of regulating stormwater is to keep it from going off the property, and yet in this plan, they are specifically sending it off the property. But the other point I would say is that down at the bottom, Mr. Hoagland makes a note, and I think he just made a mistake. He says the sediment and erosion control plan confirms stormwater management. Well, that's not the same thing as designing a project to minimize stormwater runoff off-site. Yes, they did do a stormwater management plan, right? They did the sediment and erosion control plan, which did stormwater management. You know what their stormwater management was? To send it off-site. Not to keep it on-site, but to send it off-site. So they maximized, instead of minimizing stormwater runoff off-site, they maximized stormwater runoff off-site. And Mr. Hoagland didn't question that. He just said, okay, stormwater management equals designed to minimize stormwater runoff off-site. That's not true. You can manage it, right? But their management is sending it off-site. So I submit to you the SNIA was inappropriately issued without sufficient documentation that the standards, again, in your own ordinance require. Okay, so let's look at the watershed protection permit. And I will note, and I have an expert when we do get to the merits who will come and tell you that this project was not designed to minimize stormwater runoff off-site. And in fact, they could have implemented a system which would allow them to keep all their stormwater on their beaucoup acres of property they have here as they're developing. This is not like one little tiny acre of land. This is a huge plot of land. They have plenty of land to spray that stormwater on. They don't have to send it into the creek off-site down the road. They can keep it on their own property. They do not have to pipe into the Keysville Creek. Okay, but that's my experts for another day. On the state, on the watershed protection permit, which again is required by your own ordinance. They filed this in 2019, right? Your own ordinance says that the watershed administrator, and that's Mr. Hoagland, his duty is to ensure that the application is complete, right? And that once he does that, he has 15 days to make a decision. And that's in that section. But anyway, there's a section that says, okay, they should be filed with the watershed administrator. Okay, and they have to include supporting documentation being necessary by the watershed administrator. Right? So on this watershed protection permit, Mr. Hoagland told them they need a SNIA. Okay. They need a spill containment plan. They need an environmental assessment application as well. And the site plan needs to demonstrate 30-foot undisturbed, all these buffers since the SNIA is required, right? So that's in 2019. Now this ordinance was not, your ordinance was adopted in 2014. It hasn't changed. It's not Mr. Hoagland's obligation to make sure that they file a complete application. This ordinance tells them what they need. His job is to need something extra, okay? Fast forward, December, the HIDO gets adopted, okay, which applies and requires all this other stuff. But let's just even forget that. If we look at the SNIA, they didn't even submit a complete application until, as he indicates, January 7th. All right? So I don't know where all this vested right stuff comes from, but my argument is that the SNIA shouldn't have been an issue because they didn't comply with the HIDO. But even if they did comply with the HIDO, the watershed permit is required, and they did not appropriately file a completed and all required information for the watershed permit. So again, you know, that's all I have to say.
Thank you, Ms. Baker.
Ms. Bacon, can you tell me what watershed is it your position that these particular facilities are to be located in? Because I ask the question
Say
because
that again, what?
what watershed?
Well,
Under the regulations.
I know I am, I'll tell you this, because Mr. Hoagland, assuming he applied the ordinance, right? It could only be in under your own ordinance. It could only be in either WS2BW, which is County Line Creek, Fuller's Creek, South Hyco Creek, and Stony Creek, or it has to be in the 10.8.5 Hall River Protected Area. Well, I know it's in the Hall River watershed, but it doesn't really matter. If it's not in one of those two, you can't even issue a SNIA.
Okay, that's not where I was.
That's not what you're asking? Okay.
That's what, because 10.8.5, for example, applies in one category of watershed, right? But
10.8.5, yeah. Right. Well, let's get back to Mr. Brian's jurisdiction argument. Your own ordinance sets out your jurisdiction in 10.7.1, right? And then in 10.7.2, there are exceptions to applicability, which again, I argued you can't violate federal or state law, but the watershed areas you designated come straight from DEQ, right? In 10.7.1. Right, so either it's in the Hall River watershed or it's in those others in which SNIAs are allowed.
thank you. And one last question regarding with respect to the application of the federal or state regulations, is there anything explicitly in the watershed protection ordinance that says out loud in plain English that the watershed review administrator is supposed to consider those federal and state regulations also?
I would say not explicitly, but implicitly, because you only get the authority to have this ordinance from state law. State law says you can do it, okay? And in the state law that says you can do it, it says you can't do it any other way but this. And the state is obligated to meet those federal law standards because the federal government has allowed the state to intervene or get involved in these areas. And the federal government only does that if the state agrees to enforce the federal minimum standards. So you can't interpret your ordinance to allow the county to allow people like Sunrock, entities like Sunrock, to violate state law or federal law, because it all flows from federal law. The federal government sets the minimum standards. All the federal government's done is shunt off the responsibility for enforcing its own standards to the state. And then the state just shunted them off to you. But you can't do anything but enforce those federal standards. You can't act inconsistently from them. The federal government has taken over this area, preemption, if you will. The federal laws and regulations govern everything anybody can do. They'll let you dabble in it, but you can't dabble in it inconsistently with the federal standards. And the states agreed to comply with that. And they say that when they let you do this, they say, we're going to let you have your own ordinance, but if you violate it, we're going to take it back from you. And they say, and if we catch you not doing it, we're going to come in and do it for you. So I don't know, you can tell me you have your own ordinance, but you're pretty much hamstrung by what the federal government has told you you can do.
Do you know whether Sunrock, the applicant, would have to get any state or federal permits?
I'm sorry?
In addition to the county permits for these.
Do I know if Sunrock would?
Have to seek approval from a federal or state agency to get permits to operate these facilities?
I think on one of these, where are those little permits? I mean, they do have to get, it's not federal, okay, so that gets into the whole NPDES system. Okay, so we've got the Division of Water Resources, and we've got the Division of Energy, Minerals, and Land Resources. I can't tell you why stormwater management is not under water resources, but that's how DEQ has it set up. So to get a stormwater permit to do that, they can't even build this, of course, without the stormwater permits in the NPDES, which are issued by what they call themselves as Demler, because they love those initials, right? So Demler has to give them these 2 permits. And one thing that Demler is supposed to require is for them to show that there's no alternative to surface water discharge. Well, when they filed those applications, they said there was no alternative to surface water discharge. But again, as I told you today, I have an expert who says they can absolutely keep all that stormwater on their own property, right? They don't have to pipe that stormwater into Hughes Mill Creek. They can keep it right there on their 90 acres or however many they have, right? But anyway, they did get those permits. Those permits are on appeal, with the state. So they have to have those permits to do anything anyway, but they have to have your permits to do stuff too. It all kind of works together. Division of Water Resources cares about the water you drink, right? And that water, that stormwater that's being pumped into Hughes Mill Creek, theoretically could end up in somebody's drinking water, right? That's why we have these water supply watersheds, because we care about what goes into the water supply and in the watershed, right? But that's completely siloed off from these crazy stormwater permits. And the connection is the stormwater permit, they're supposed to say why they have to put it in the creek. And they said, oh, we do. We don't have enough land to not put it in the creek. And honestly, if we have a hearing on the merits, my clients will testify that DEQ came to the hearing in Superior Court and said, we can't possibly require these people to show us all that. We have to issue these permits every day. We can't possibly enforce our own laws and rules, right? Their own rules tell them they have to get evidence from Sunrock that they have to pump it into the creek, right? That there's no alternative, right? And on that application, Sunrock said, oh, not approved. And DEQ, because it's Demler and they don't care anything about the water supply, said, oh, okay, that's fine. And their lawyer admitted they don't have time to enforce the laws they have. And I asked the judge, Your Honor, if they don't have time to enforce the rules and the laws, they need to change them. Because by golly, you shouldn't have laws and rules that you don't have time to enforce, right? get rid of them. You don't want to enforce them, don't enforce them, but you got laws and rules that tell you have to do it. And they argued, my clients will testify, they heard that lawyer say, we don't have time to do that. We don't have time to enforce our own rules and laws. I am not making this up. I mean, there's a transcript where he admitted that.
Thank you, Ms. Baker. Fellow board members, any questions for Ms. Baker? Okay, seeing none, Mr. Hornick, is it now appropriate to recognize Mr. Conklin? Chair now recognizes Mr. Conklin.
Thank you, Mr. Johnson. I want to join Mr. Farrell in thanking this board for its service. I've served on some local boards. I know how much time and commitment it takes, how many headaches it causes. So thank you for your service. I want to also next answer directly Mr. Hornick's question to Mr. Bryan earlier about what the moratorium applies to. And I want to quote language from the moratorium ordinance in that respect. Section 6, and I quote, says, "There is hereby established a one-year moratorium on any approval required by Caswell County for any polluting industry development," close quote. Polluting industry development is defined to clearly include Sunrock. That's in section 3, subsection 6, where it defines polluting industry development to include mining and resource extraction facilities, hard mining, resource extraction, and quarrying, asphalt plants, and cement manufacturing. So I don't think anybody would argue that Sunrock is not a polluting industry development, and the moratorium applied to any approval required by Caswell County. Mr. Johnston and honorable board, my folks, these 50 or so of your neighbors have been waiting over a year and a half to get their appeals heard. And we're not blaming anybody sitting up there for that. We're not blaming anybody except maybe Sunrock. The reason we waited so long is because Sunrock, when we filed appeals here, turned around and filed a Superior Court lawsuit against these citizens, these neighbors of yours, and made them go hire lawyers and defend themselves for a year, spending lots of money, lots of headaches, lots of sleepless nights. And then Sunrock pulled the rug out from under it and dismissed it after monkeying around with us for a year. Now, after a year and a half of monkeying around with us, they come here and ask for you to dismiss this appeal. What's the game plan here? The game plan is make sure the citizens, your neighbors, don't get a chance to be heard. That's the game plan. They can wrap it in whatever legal niceties they want, but they're trying really hard to make sure these folks don't get to be heard by their government, which is in violation of the Constitution. That dismissal of the Superior Court action was allegedly because the Superior Court could have dismissed it itself. It didn't. It dismissed against these folks, but our folks didn't ask for a dismissal because we wanted to get this thing heard. We wanted to get a decision. Are there vested rights or not? Did the moratorium apply or not? We think the answer to those questions is clear, and we think the reason that Sunrock doesn't want to have a hearing in Superior Court or here or anywhere else is because they think the answers are clear and they lose on those questions. And so they're trying to keep you from hearing this case and making the decision you need to make. Honorable board, Mr. Johnston, county employees are not supposed to ignore the law. They're not allowed to ignore it. So this argument that all they can look at is this little narrow subset of things and they can violate any other laws they want to, that's nonsense. Complete and utter nonsense. They have to follow the law. We'd like to hand up a case. It's Thrush versus County of Buncombe. It's a Court of Appeals case from 2009, but it's just a case. There's lots of cases saying that county officials have to follow the law. But I wanted to give you one example. And perhaps even more importantly, I wanted to point out to you that North Carolina General Statutes 160D, everybody in the room agrees 160D is what governs county actions. 160D 403F says, and I quote, any development approval, these two were development approval, any development approval mistakenly issued in violation of an applicable state or local law may also be revoked, close quote. So everybody, I've been doing local government law and state law, environmental law for a long time. And I have never heard someone make an argument that, yes,
Sir, can I get one of those?
which one, sir?
We just next out.
Oh, there should be enough.
That will be enough for you.
Oh, we had 10 copies. I'm sorry.
Take mine.
I apologize for being short on the copies. So, as I was starting to say, I have never heard an argument that a local official doesn't have to comply with all the laws, that they can violate other laws as long as they narrowly focus on one law and pay attention to that. Now, what law am I referring to? I'm referring to the moratorium, of course. The moratorium I just read to you applied to any approval required by the county for a polluting industry development. Let's talk a little bit about the timeframes. The moratorium took effect on January 6, 2020. It was later extended, it was for 1 year at that time, it was later extended to be in effect until July 6 of 2021. So January 2020 to July 6, 2021. The 4 permits we're challenging, the SNIA for Burlington North, Sunrock Burlington North facility was issued January 4th, 2021, while the moratorium was in effect. The watershed protection permit for Burlington North, for Prospect Hill was issued January 5th, 2021. The SNIA for Prospect Hill was issued January 6th, 2021. The watershed protection permit for Burlington North was issued January 7th, 2021. So all of them were issued while the moratorium was in effect. They were all illegally issued because of that. Moratorium clearly says that shall not happen. Now, I assume that Mr. Hoagland went ahead and issued them because he thought that Sunrock had vested rights. And if you're not familiar with vested rights, what it means in just the quickest nutshell is if you've gone out and done some things in reliance on a county law that says you can do them, the county can't then pull a rug out from under you and say, we've changed the law, you've got to comply with some new laws. That's vested. You've got the right to comply with what was in effect at the time you spent the money and got your permits. Typically, you've got to have a building permit for it to apply. It's much more complicated than that, as we'll all tell you about it. This goes to the merits. But typically, you've got to have a building permit. And once you've got that, you can rely on what the current laws were. That's what Sunrock's been arguing. If Mr. Hoagland thought that Sunrock had vested rights, that would have given him a reason to ignore the moratorium. So as you can see, vested rights and moratorium are part of this decision. They have to be, unless we think that Mr. Hoagland's a nincompoop, because the moratorium, and I don't think he's a nincompoop. I think he's a smart, honest man. But that's the only way he could issue these permits without thinking about and making a decision about the moratorium, because the moratorium is clearly in effect. As you know, Mr. Hoagland's also the planning director. He knew about the moratorium. That wasn't a secret to him. And for him to issue these permits while the moratorium clearly said he could not, he had to make a decision that there was a reason the moratorium didn't apply. And the only reason anybody's argued it didn't apply is Sunrock's argument that they had vested rights and it couldn't apply. So he made those decisions. This board is set up to review all decisions made by the watershed administrator. And so it is fully within your bailiwick, fully within your jurisdiction to review what he did. Either it's an easy decision, which is there was a moratorium, said he couldn't do it, it was wrong, and they're reversed. That's the easy decision, because it's in black and white, shall not be issued. And he did it anyway. So that's the easy decision, is they have to all be reversed because there was a moratorium. If Sunrock wants to argue, I'm not gonna argue it. If Sunrock wants to argue that they had vested rights, they can do that. And that might get it back to where it was okay for him to issue it, if you agree that they had vested rights. We don't think they did. But that's their argument.
Mr. Connor,
Yes, sir.
putting the vested rights argument aside for a second. Do you think that the permit choice statute plays any role at all in this appeal? And I'm talking specifically about 143, 755, the general statutes called permit choice.
I'm generally familiar with the permit choice statute, sir, and I do not think it plays a role.
Can you elaborate on that a little bit more?
Not much. I haven't really looked at it much, to be honest. But I don't think it does. I don't think they qualified for that. I read it months and months ago in this case and made a determination to my own satisfaction. It did not apply, but I'm not fresh on it. I apologize.
I hope we'll all get a chance to answer that question.
One at a time.
I'm sorry?
So one at a time.
I'm certainly glad for Ms. Bateman to answer that for me.
No, I mean,
As time comes.
I think that just goes to what we're about today, which is whether it's on the merits or the motion to dismiss. That's all. I mean, I look forward to having an opportunity to brief that issue.
And thank you, Ms. Bateman. That's a great point. I mean, yes, we're talking about motion to dismiss today. And when we have our full hearing, I'll certainly be ready to talk about the permit choice statute. Yes, sir. So that's it's sort of that simple, folks. I'd like to give you, another half hour of complicated stuff, but it's not necessary. The moratorium was in effect. It's said there shall be no development approvals issued during that period of time for polluting industry developments. There's no question that Sunrocks is a polluting industry development. The permits were illegally issued. That is before this board because the laws apply. This is a county ordinance and this board gets to decide everything, review everything Mr. Hoagland decided. How did he issue those if there was a moratorium in place? That's for you to look at and decide whether he had a good reason to issue them with a moratorium in place or not. That's what you have to look at because that's what he did. I also just want to briefly touch on a couple of things. One is Brian Farrell's role, and I know Brian would agree with me on this. It's not controversy, but I just want to remind, because you're a county board, here sits the county attorney. And here sits the county attorney. The county attorney does not represent this board. That's why you've got Bob there to represent. It was determined it was a conflict of interest because he's representing and defending the decision Matthew Hoagland made. He's not here to impartially advise you. He's here to represent a client just like I am and just like Mr. Bryan is and just like Ms. Bateman. It's just for clarity. And then I certainly hope this argument has no effect on you, but I did hear Mr. Bryan make the argument that, well, you better dismiss this because it's going to take a long time to hear it if you have to hear it. And I respect y'all enough to not think you're going to fall into that. But let me just assure you that there is no reason for it to take days and days and days and days to hear this. We fully intend to find ways to streamline it. We intend, with permission of Mr. Hornick, to file affidavits on standing instead of doing live testimony. I can't predict exactly what everybody's going to agree on, but we're going to find a way. My clients can't afford to have me doing days and days and days of testimony. That's not something you need to worry about. Thank you very much for your attention. I'd be glad to answer any questions that I can answer.
Yes, thank you, Mr. Connor. Fellow board members, I'll ask again, any questions, Mr. Connor? Okay. Mr. Hornick, any additional?
What made the county, do you know what made the county impose a moratorium at that time?
Yes. I do not know. I was not at those meetings, and so I'd be reluctant to speak for the county commissioners on why they imposed a moratorium. I just know that if they did, that it was a law at the time these permits were issued. Thank you. Thank you, sir.
Thank you. Any additional questions or comments? Okay, Mr. Hornick informed me that Mr. Bryan did ask for a rebuttal argument. Is that appropriate at this time?
Thank you, Chair. Thank you, Mr. Chair. Regarding Ms. Bateman did a very good job of laying out her argument and showing exactly why this board doesn't have jurisdiction over.
I can't hear. I'm sorry, I can't hear. Let's switch microphone.
Ms. Bateman did a very good job of laying out all the reasons why this board does not have jurisdiction over her client's appeals. They're based entirely on state and federal law. This board does not have the power or the authority to apply state and federal law. It is only constituted to apply the watershed regulations. And there were a number of false statements made. One of them, there is a spill containment plan, which is on the county website for this project. You can look it up yourself. With regard to Mr. Connor's arguments, the people who filed these appeals, it's clear to me, did not understand exactly what they were doing. They did not understand that by filing the appeals, they were filing a lawsuit. And that there was going to be a hearing that people were going to have to swear and be sworn and give testimony at. They should have filed a case in Superior Court. We tried to take the case to Superior Court, and we would have been happy to have had it stay in Superior Court. But we weren't able to do that, and so we had to make the decision to bring it back to you. If you recall, a year ago, we all agreed that it should be in Superior Court, but Superior Court did not agree. And that's why we are back where you are. If the Superior Court hadn't done that, we wouldn't be here. This has never been a question of trying to delay things. Anybody who wants to move fast, it's us. And so I take great issue with that argument. And finally, I would just note that Mr. Connor is very forthright, very honest in his statement that his entire argument is about vested rights. And I respectfully submit that your board does not have the jurisdiction to make determinations of whether somebody has vested rights or doesn't have vested rights. It's not within the ambit of your jurisdiction. And so we would request that you dismiss Mr. Connor's client's appeals so they can go back to Superior Court where they belong. And that you dismiss Ms. Bateman's appeals to the extent that they are based on anything other than the watershed regulations, which is why your board exists, is to apply the watershed regulations. We appreciate very much your service. I was on the Board of Adjustment for 14 years. And I know exactly how much time it takes to do what you're doing, and I really do appreciate it. And I'd be glad to take any questions you have.
Thank you, Mr. Bryan. Fellow board members, any questions for Mr. Bryan?
Brian, one question. I may have asked before, but maybe I didn't. Can you explain to this board why the moratorium didn't apply to Sunrock's application?
Well, the moratorium didn't apply to Sunrock's application because Sunrock had vested rights. And it was determined by the county that Sunrock had vested rights. So that was a decision that Mr. Hoagland didn't make. It was a decision that was made by the county board, and it was made by the county attorney, and it was made by the county manager. And we've attached to our application the vested rights determinations that were made by the county. And so the whole issue, as Mr. Connor has been very honest about pointing out, the whole issue here is that the county had determined that there were vested rights. If you want to challenge that determination, you have to take it to a different court. It is not a determination that can be challenged here. It's a determination that's supposed to be challenged in Superior Court.
Would that have been a Board of Adjustment, appeal to a Board of Adjustment first?
Only if there was a determination made by the zoning administrator to that effect, and I don't think it falls within the statute. Or not here. The question was, should have gone to the Board of Adjustment first. I said, I don't think there would have to be a determination made by an administrative official that it gets appealed to the Board of Adjustment. Is that what you're getting at? And I'm not aware that determination has been made by an administrative official that can be appealed to the Board of Adjustment at this point.
I understand. I think I understand your argument. I mean, you can see that at least the question I'm grappling with is if they can move forward with their application because they have vested rights, someone must have somewhere along the line said, gee, yeah, they got vested rights.
Right, and that determination could be appealed, if it were in the proper form, it could be appealed to the Board of Adjustment. Or you could bring a lawsuit to the Superior Court, which is what we believe should have happened in the first place, which is why we brought the lawsuit to the Superior Court. The problem was that we couldn't sue the county because the county had recognized our vested rights. So we sued the people who had challenged our vested rights, but the court said that those people couldn't interfere with our vested rights, and therefore that we didn't have a claim against those people, and sent it back down here for determination to be made, so that the people who have a complaint with the county are the appellants, not.
You said that the county recognized that they had vested rights. What form did that recognition of vested rights take?
It took the form of a determination that was signed by the county manager and submitted to the state. After the county adopted the legal opinion that was written by Mr. Tom Terrell, who was a special counsel hired by the county to analyze vested rights issue.
Was that the zoning compliance letter? Is that what you're talking about?
They were attached to the zoning compliance letter.
Mr. Hornick, if I could just give you a date there. The date of that zoning compliance letter you're mentioning was March 30th, 2021, 3 months after all these permits were issued.
Well, I appreciate that, but the county had made that determination already. At that time, it was all of the original lawsuit. And it was put into writing on March 30th. One of the other thing about the moratorium that hadn't been done was the fact that the moratorium expired. So I think even if the permits were probably issued in the moratorium, once the moratorium expired, the permits come in since then. So the bottom line is that all these issues are issues that need to be fought out in front of a judge in Superior Court, not in front of the Watershed Review Board. There are going to be pages and pages of legal briefs in connection with these issues. So our position is that the appeal should be dismissed, the case should move along and only be focused on things that are considered to be technical violations of the watershed regulations by Mr. Hoagland.
Okay, thank you, Mr. Ryan. Mr. Farrell, would you like to add in rebuttal?
I don't have anything further. Thank you.
Thank you, Mr. Bill. Ms. Baker. Do you have anything to add as far as the rebuttal?
I would just like to offer up a citation to the general statute that I spoke about earlier, 143-214.5, where it says that if a local government fails to adequately carry out responsibility to enforce the minimum water supply watershed management requirements, the commission will come in and do it. And it says in E that the commission shall assume responsibility for water supply watershed protection if a local government fails to adequately administer and enforce the provisions of its program. So, the state says you have to follow its rules, and the state gets its rules from the federal government. That's how these things all come together. And that was what I understood the issue to be this hearing today. We look forward to talking about vested rights, whether or not Sunrock, Mr. Hoagland should have made them comply with the HIDO, which did come into effect in December, because their application wasn't complete until January. I don't think you get vested rights until your application is complete, but that's a story for another day.
Thank you, Ms. Baker. Mr. Collins, I'd like to add a rebuttal.
Thank you, Mr. Johnson. A couple quick things. I've been handed a note that says that the county did not have a board of adjustment until late 21 or early 22. I don't have personal knowledge of that, but I've been handed a note that says that. I'm sure y'all probably know. And that would just go to the question of, should we have appealed it to the board of adjustment? There wasn't a board of adjustment. So, and then just to reiterate very briefly, this moratorium was unquestionably in effect. If anybody made a decision about issuing these permits in spite of the moratorium clearly says you can't do it. It was Mr. Hoagland who was the person who issued it. He had to make a decision that there were vested rights, or else he had a really bad day where he forgot about the moratorium, one of the other. And that issue was before him. He made the decision. You get to review the decisions he makes. It's as simple as that. Thank you.
Thank you, Mr. Cox.
One point of clarification, just so I'm clear, the county did have a board of adjustment. Commissioner staff is the county board of adjustment. There wasn't a separate board at the time. So that's a technical, difference, but I thought it was worth mentioning.
Yeah, it's a fairly common arrangement. Okay, thank you all. Fellow board members, any other questions or comments? Mr. Horning, could you clarify procedurally where we are?
Well, I think we completed the hearing on the motions today. I think the point we're at right now is for you, Mr. Johnston, to either take the matter under consideration, or if you feel like you're prepared to make some kind of decision, make a decision, which eventually we're going to have to put down in writing, because it would be the filing of your written opinion would be the appealable, I think, determination.
Thank you, Mr. Horning. Considering the tremendous amount of information that we've received over the last few weeks and the well-crafted oral arguments that we've received today, I don't think I'm ready to make a determination at this time. I think it would be wise, prudent to take this matter under consideration. So we're not ready today to make a decision. So certainly, council, that being said, a decision on the motion to dismiss will not be made today. Our regular scheduled planning board meeting will be the fourth Tuesday of next month. Is it appropriate to confer with Mr. Hoagland at this time? Mr. Hoagland, is that meeting, you have availability to that day, as well as fellow members? We want to check our calendars and make sure the fourth Tuesday of December, I believe that's 27th.
Mr. Chairman, just a couple of items of information. Technically, the next planning board meeting is scheduled for a week from today, which would be November the 22nd. That is 2 days before Thanksgiving. The fourth Tuesday in December is the 27th. That is technically part of a 3-day county holiday in which all county offices will be closed.
Mr. Hoagland, how do you feel? You're our planner will certainly need to be there in both roles. How do you feel about meeting sometime in January, either the regular scheduled meeting or possibly another special meeting before that?
I'll be glad to make myself available at any date that the board deems appropriate. I don't see any major scheduling conflicts for myself for January, certainly the fourth Tuesday of January, which is a regularly scheduled date. I plan to be available, and that would certainly work for me. That would be the 24th.
Okay. How about co-counsel?
Your Honor, it's just been pointed out to me, I've been reminded that we've got a hearing already set on the calendar for Tuesday, the 24th through Thursday, the 26th, I think. So that we would not be able to attend on those dates in January.
Are there any other dates in January?
I think we could make anything else work.
Co-counsel, how about January 17th?
Can I suggest, I was going to suggest this. That's clear for me.
Mr. Farrell?
Should be fine. I still keep a paper calendar, so pull this out.
And Ms. Baker, whenever you're ready. That day work for you.
And this is for,
This would be an additional special meeting to issue, the chair would issue the opinion and then possibly the remainder of the board would potentially hear an appeal that day as well.
so it will be here the merits of the appeal. If the motions to dismiss are not granted,
Correct.
and that would be on what day?
We're considering January 17th.
And I'm
Mr.
we're not
Johnson.
talking about having an evidentiary hearing on January 17th, correct? We're talking about having a hearing to discuss the decision.
That's correct. The decision.
If there's a need for an evidentiary hearing, we would have to schedule that for some other time, is that correct?
That's correct.
I'm sorry, can you repeat what he said?
Basically, that the purpose of the meeting of January 17th is for the chair to render his opinion, his decision. And you, all council, you may have a right to appeal to the full board from whatever decision the chair makes. The hearing on the merits, if we ever get to that, will be on the 17th of January.
Oh, my gosh, okay, I thought you were talking about hearing on the merits. So confused. All right. You can't just go ahead and like decide it? Can't you all just decide it? And if we want to appeal it, we decide to do that?
Sure, we can, but we're not doing that today.
Okay,
17 is fine for me.
Thank you, Mr. Farrell. Fellow board members, I'd like your input as well, as far as that day work for everyone. All right, any other input from council? All right, at this time, I'll entertain a motion to continue the Watershed Review Board hearing to January 17th. Motion by Mr. Daniel to continue the Watershed Review Board.
Mr. Chairman, can you specify time and location on the 17th?
Yes, sir. January 17th, 2023, excuse me, 1 o'clock here at the same location, Old Castle County Court. That is a motion. All those in favor, let me know by saying aye. Aye. All those opposed, like sign. Motion carries. Mr. Horning, if you need to have a motion to close the public hearing. All right, at this time, I'll entertain a motion to close the public hearing. Excuse me, to continue the hearing until, we've already made that motion. If there's no other business before the board, I'll go ahead and entertain a motion to adjourn. Motion to adjourn. Motion to adjourn by Mr. Harris. All those in favor, let me know by saying aye. Aye. All those opposed, like sign. Motion carries. Meeting adjourned.